Hi, I'm Swapna Anthur from the Anthur Law Group. We are located in Fremont, California. The reason I'm here today is to talk to you about the child custody issues. When you're going through a divorce, and if you have minor children, child custody and visitation could become an important issue in the case. Also, if you're in a relationship and you have children with the other partner, and if the relationship ends, then also child custody will become an issue. Now, let me talk a little bit about how child custody and visitation is handled by the courts. California courts like to see both parents being involved in the children's life. However, this may change if there are any allegations of abuse from one parent towards the child. If there is domestic violence in your case, and if the court makes a ruling or finding of domestic violence, the court may also limit your access or visitation with your children. If there are no issues of abuse, and if you believe you have the ability to co-parent with the other parent peacefully, you can get into a custody and visitation agreement and file it with the court. If you both are in agreement regarding the visitation plan, the court would accept the plan and the judge will sign the agreement and it will be filed with the court, and thus it will become a formal order of the court. In this agreement, you could address the custodial days or time with each parent, holidays and vacation time, birthdays, Father's and Mother's days, etc. Since this is a formal order, it is required that both parents comply with the court order. If you're unable to get into an agreement regarding custody and visitation, then you will need to get an order through the court. This is achieved by filing a motion for child custody and visitation with the court. And you file the motion, the court sets a hearing date to hear the motion. The court also refers parties to a court-appointed mediator who will sit with both parents and will help the parents get into an agreement. However, if there are no agreements between the parents, the mediator makes recommendations and will provide a report to the court. Both parents will receive a copy of the mediator's report and will have an opportunity to present any of their objection to the court regarding the report. The court will hear arguments from both sides and then will make a ruling on the issue of custody and visitation. It is important to note that the child custody is always modifiable until the child reaches 18 years of age. So if you are currently having an order which you believe is not in the best interest of your children, do not worry, as you can file a motion to modify the custody order. But you will have to demonstrate a change of circumstances when you seek modification of custody. Also, you will always have to show the best interest of the children when you're approaching the court to modify the custody in your favor. If you find yourself facing such a situation and you want to establish a good child custody and visitation order, please talk to an experienced attorney who handles such matters on a regular basis. If you have any questions regarding child custody and visitation issues, please click the link below to schedule a consultation with someone from our office.